We have today speakers from Dickinson and from Llinks law firm who will be talking about two different topics. Now, firstly, we will have Patrick Zheng and Charles Cheung of Llinks law firm talking about latest developments in transnational litigation in China. And then we'll have Damien Laracy and Felix Cheung from Dickinson talking about plans to adopt the United Nations Conventions on Contract for the International Goods in Hong Kong. We encourage all the participants, all the attendees to actively ask questions from the speakers. For that, you can type in your questions in the Q&A box, not in the chat box, but in the Q&A box in your Zoom panel. Once we receive the questions, we will put these questions forward to the speakers who will get back to you at the end of their presentation. After this webinar ends, there will be a post-webinar survey. For many of you, you will be receiving an email in your registered email ID with the survey link. Because this particular webinar, we have Hong Kong CBD points which have been applied for, it's quite important that we fill in the survey and we get feedback from all the attendees. A little bit about in-house community. As you may know, we are a community of about 17,000 in-house counsel across Asia and Middle East. We have two events which are coming up. I'll be sharing with you information about these two events at the end of the webinar. We also have the IHC magazine, or previously called the Asian MENA Council, as well as the IHC briefing newsletter, which goes out twice a month. Our mission: to strengthen legal and ethical compliance for all. Now, without further ado, I'd like to invite the first speakers, Patrick Zheng from Llinks law firm and Charles Cheung, who will be joining after Patrick's presentation. A quick introduction to Patrick. For those who don't know, Patrick is a partner at Llinks law firm. He has 20 years of experience and has established a round reputation in cross-border dispute resolution and international arbitration and litigation. He's qualified to practice law both in China and New York. Mr. Zheng is also a panel arbitrator for various arbitration institutions like CTAG, SCIA, SIAC, HKIAC, the KCAB, KLRCA, and more. After Patrick's presentation, we'll have Charles Cheung, who's also a partner at Llinks law firm. He's been practicing PRC law for over 3 decades, with rich experience in banking, corporate finance, private equity, venture capital, and asset management. He shifted his practice from transactions to dispute resolution about 15 years ago. He's also currently a panel arbitrator of SCIA, SHIAC, and SHAC, and a member of Chartered Institute of Arbitrators. He's also a council member of the China Society of Private International Law. So without further ado, Patrick, I'd request you to now start sharing your screen and start your presentation. Thank you.
Thank you very much, Rahul, for your kind introduction. And today, Charles and I will share with you the latest developments of transnational litigation and international arbitration in China. The Supreme People's Court issued the minutes of the National Symposium on Foreign-Related Commercial and Maritime Trial Work of Courts in 2022. And this minute actually covers a wide variety of issues and with respect to transnational litigation in China and international arbitration with China as the seat. And today we're going to share with you the following issues. I will cover the first 4, and Charles will address the last 2. So let me begin with exclusive jurisdiction agreement. And jurisdiction agreements is also called choice of court agreement. And in this minute, the Supreme People's Court decided or held, any choice of court agreement which is not specifically referred to as an optional jurisdiction agreement shall be regarded or should be presumed to be exclusive. So this is an interesting area, that what is exclusive choice of court agreement and what is optional. And the PRC civil procedure law is silent on the validity and enforceability of the choice of court agreement. But there are some tips that we can find in the law and in judicial practice, that this type of agreement should be in writing, just like arbitration agreement, and including electronic communication. And the choice of court agreement is separable and independent of the main agreement, the main contract. Again, this is very similar to separability doctrine in arbitration. So amendment, revocation, or termination of the main contract will not affect the validity of the choice of court agreement. And under Chinese law, unlike common law jurisdictions, some of the countries that the jurisdictions are statutory. And Article 35 provided the choice of court agreement can be reached by the parties, and they can choose among the following 6 choices. And the first one is the defendant's domicile. This is very similar to the Brussels I regulation. And actually, with China adopted European approach when promulgating a civil procedure law. And the second one is the place where the contract is performed, the place of performance. This is also similar to Brussels I regulation. And the third is the place where the contract is concluded, and also the plaintiff's domicile and the place where the subject matter is located. And also the last one is any other locations which have actual connections with dispute. So the parties can choose among the 6, provided that the provisions on hierarchical jurisdiction or exclusive jurisdiction are not violated. So what is exclusive jurisdiction? Under Article 273 of the PRC Civil Procedure Law, that any dispute related to or arising from performance of Sino-foreign joint venture contracts, Sino-foreign cooperative joint venture contracts, or Sino-foreign exploration and exploitation of natural resources contracts, shall be decided by Chinese courts. And also, a real estate disputes arising from port operations and disputes arising from inheritance. Chinese courts exercise a exclusive jurisdiction. So we can look at Article 24 of the Brussels I regulation, and which provides for exclusive jurisdiction. And the first one is rights in rem, in immovable property or tenancies of immovable property. The Chinese law is silent. The Chinese law only refers to disputes related to real estate. But actually, what is in rem, rights in rem, in immovable property, is a rather complicated issue. And Chinese law is not very clear about what is in rem dispute, which should be regarded as a right against the law, and what is in personam dispute. If any in rem dispute, which is actually in personam, for example, that A claims against B that the house is A's. Whether this type of dispute is in rem or in personam, the Chinese law still is not very clear about it. And the second one is about companies or other organizations. And the Lex Citus, in other words, the court of the location of the company shall have exclusive jurisdiction. But still, Chinese law is not very clear. What are the disputes related to companies? And the Brussels I regulation and the common law, they are quite similar, that the nullity or dissolution of companies or legal persons or any validity of the decisions of their organs shall be regarded as company disputes. Otherwise, other disputes can be litigated in other forums. And also the validity of entries and also the validity of patents, like intellectual property, and enforce of judgments. So the courts exercise exclusive jurisdiction. And in this case, the parties agreed on the sole jurisdiction of the Hong Kong court. And the court, the Shanghai High Court, held that this is exclusive choice of court agreement, which was decided in 2018. And in some jurisdictions, exclusive jurisdiction is presumed in case of controversy, like Romania, Greece, Czech Republic, and Japan. And the conventional choice of court agreements and the Brussels I regulation also presume exclusive jurisdiction. But in some countries, they are not regarded, they are not presumed to be exclusive, and which requires the court to construe the agreement to decide what are the true intentions of the parties. So let's move on to recognition and enforcement of foreign courts, foreign judgments. And in these minutes, Supreme People's Court provided that a reciprocity can be presumed, that if a civil or commercial judgment of Chinese courts can be enforced or recognized and enforced in a foreign jurisdiction, then the reciprocity is presumed. Or China has reached an understanding or a treaty with a particular jurisdiction. And also, if there's no any evidence to prove that the particular country in which the recognition and the enforcement of Chinese judgment is sought has refused to recognize or enforce the judgment, then this constitutes the ground of reciprocity. So because of time, I want to skip this part and let's move on to the grounds for non-recognition of foreign judgments. Article 46 provides that if there's no jurisdiction over the case, if the foreign court has no jurisdiction, but there is no classification, distinction between personal jurisdiction and the subject matter jurisdiction. And this, we normally call it jurisdiction. And the second one is the respondent has not lawfully been summoned, and there was a violation of due process, which is very similar to any other countries. And the third one is the judgment is obtained by fraud. And again, this should be extrinsic fraud rather than intrinsic fraud, which means the fraud was conducted against the judge, against the legal proceedings, rather than between the parties. In that case, Chinese court will not reopen the judgment. And there was a conflicting judgment, and also that foreign judgment violates public policy. So these grounds for non-recognition and enforcement in the United States. So if you look at these grounds, the first one is lack of personal jurisdiction and subject matter jurisdiction. And also the second one is lack of due process. They are mandatory. And there are 6 more discretionary grounds of non-recognition and enforcement. And lack of notice, fraud, again, that is extrinsic, and repugnance of the cause of action against the public policy, and inconsistency with other final judgment, and also serious inconvenience or an inconvenience. So the third issue I want to share with you is the preclusive effect of any issues decided by the previous tribunal or previous court over the subsequent tribunal and subsequent court. And this is a very interesting issue that because this is a case study. There is a license contract which refers to HKIS arbitration between Refers International and Hainan Airlines. And there was another kind of hotel management contract, which was referred to city arbitration in Shanghai between Hainan Airlines and the Raffles Beijing. So the question is, if HKIS arbitration tribunal decided an issue which falls within the ambit of the CTEC arbitration, then what happens? And actually, this is more relevant. This is probably admissibility of claim issue is more relevant. Res judicata is more relevant. And the common law, for example, issue preclusion or issue stop. In other words, whether CTEC Shanghai's decision is binding, decision on a specific fact or law is binding to HKIS arbitration. But in this case arose out of enforcement procedures that the losing party applied to Chinese court, claiming for non-recognition, non-enforcement of the award, claiming that HKIAC arbitral tribunal's decision is auto petita. In other words, the tribunal decided an issue or claim which did not fall within the scope of the arbitration agreement. And it's quite interesting that Supreme People's Court, ultimately because this issue shall be decided by the Supreme People's Court and the internal reporting system, that the Supreme People's Court, in their view, it is classified as a auto petita issue rather than res judicata or issue preclusion or admissibility of claim issue. And the Supreme Court said that any decision on an issue of law or issue of fact, which arguably falls within to another arbitration agreement, if the decision appears in the reasoning part of the award, then there is no preclusive effect. But the Supreme Court said that then the arbitral award is not auto petita. It's not behind the scope of the arbitral tribunal's jurisdiction. So I think this is a quite interesting point to make, that maybe further clarification may be needed in the future. So my last issue is the parallel proceeding issue, that simply put, that if Chinese court had decided on the validity of an arbitration agreement, then the arbitration agreement might be a foreign arbitration agreement with the seat of a foreign country, or Hong Kong, for example, which is a foreign-related dispute. And in that case, even the foreign arbitral tribunal ultimately rendered an award. Even that award had been recognized by the seat or by other New York Convention countries. In other words, in foreign jurisdictions, that award is effective, is valid. Chinese court will not enforce that award because it is against public policy. Because the Chinese court's decision on the validity of the arbitration agreement is res judicata. In other words, the declaratory relief over foreign arbitral agreement is decisive under Chinese law. I'm not sure whether this is a pro-arbitration approach. So I want to stop here, and I will hand over to my partner, Cheung. And thank you very much for your kind attention.
Thank you very much, Patrick. And I'll ask Charles to share his screen. And Patrick, thank you very much. And you can now close your webcam and make sure that your microphone is on mute.
Thanks, Rahul. Thanks, Patrick. Good afternoon, everyone. I'd like to share with you the two remaining issues addressed by the Supreme People's Court in the 2022 Supreme People's Court minutes. The first issue is pathological arbitration agreement. Under Article 94 of the 2022 minutes, it has been made clear that if the parties have agreed to arbitrate first and then to litigate, under those circumstances, the arbitration part of the dispute resolution clause should be valid. But the previous judicial opinion in this regard is different. Previously, if the parties agreed to arbitrate the disputes first and then to litigate, neither the arbitration agreement nor the choice of court agreement should be valid. This can be illustrated by court decision rendered by Shanghai No. 1 Intermediate People's Court, and we can find the court decision from the Supreme People's Court Gazette. So previously, the arbitration agreement incorporated in that type of dispute resolution clause should be invalid. Before the 2022 SPC minutes, the judicial opinion has changed. We can find a Shanghai No. 1 Intermediate People's Court decision from the Supreme People's Court Gazette. In that case, the parties have agreed to submit the dispute to SIAC first. And if any party disagrees with the outcome of the arbitration, then she may submit the dispute to the competent court of the place where party A is located. In that Shanghai court case, the judge held a different opinion from the opinion held by the justices of the Supreme People's Court in 2013. In the 2020 Shanghai Intermediate Court case, the judges held that the arbitration agreement should be valid. Okay, now I will share you with the last issue we'd like to address today. That is extraterritorial service of judicial documents. In Article 274 of the PRC Civil Procedure Law, it is provided that the PRC courts could serve the judicial documents by 5 channels. But the PRC Civil Procedure Law is keeping silent on whether the PRC courts could serve judicial documents to foreign natural persons if that foreign natural person has a domicile in mainland China or is holding a position in a PRC company. Under Article 12 of the 2022 Supreme People's Court minutes, the Supreme People's Court permits PRC courts to serve judicial documents to foreign natural persons if that foreign natural person is a shareholder of so-called wholly foreign-owned enterprise. So if that is the case, then the PRC court could serve the document to the wholly foreign-owned enterprise in which the foreign natural person is a shareholder. And or if a foreign natural person acts as a director, a supervisor, or a senior manager of a company incorporated within the territory of mainland China, PRC courts could serve the judicial documents to the enterprise in which the foreign natural person holds a position. Authorize the PRC, the Supreme People's Court authorized the People's Court to serve judicial documents to foreign natural persons, to their adult family members living with that foreign natural person. We know that mainland China is a member state to the Hague Service Convention. So there is a long-standing and traditional view that if foreign courts would serve judicial documents to a party in mainland China, then that foreign people's court must serve the judicial documents via the so-called designated central authority. In mainland China, the designated central authority is China's Ministry of Justice. So this is a long-standing and prevailing view. We can locate a number of PRC court decisions before 2008, in which a PRC intermediate court did not recognize and enforce a foreign judgment on the basis that service of judicial documents did not comply with a method via designated central authority or China's Ministry of Justice. On this slide, there's a hypothetical case. If a mainland China natural person is facing a court case before a US court, is it necessary that the US court must serve the judicial documents via China's Ministry of Justice, or the US court could serve the judicial documents via other means? If the US court served judicial documents via other means rather than via China's Ministry of Justice, whether the winning party will face difficulty in applying for recognizing and enforcing the judgment rendered by the foreign court. I'd like to share with you two recent PRC court cases. The first ruling was given by Ningbo Intermediate People's Court in 2018. In that case, actually, the service of the foreign court, the US court, was not via China's MOJ. Actually, service was via an entrusted law firm or a foreign counsel representing one of the parties in the relevant case. The outcome is that the Ningbo Intermediate People's Court entered a decision in favor of the applicant. Although Ningbo Intermediate People's Court, they have noticed that the service is not in compliance with the provisions and the Hague Service Convention. I'd like to share with you another recent PRC court decision, which was entered by another intermediate court located in Shandong province. This was a court decision given by Cheung Intermediate Court in late 2018. In that case, the court heard the dispute was a district court in South Korea. And eventually, the district court in South Korea served the judgment to the losing defendant in mainland China by way of making a public announcement in a Korean newspaper And during the process of recognizing and enforcing the Korean judgment, the losing defendant told the judge of the Qingdao Intermediate Court that because making an announcement on a foreign newspaper did not comply with the provisions under the Hague Service Convention, so the Korean judgment should not be recognized and enforced. But the Qingdao Court actually rendered a decision in favor of the applicant because they noted that the District Court of South Korea actually complied with its own civil procedure law in the summon process. I also like to share with you an article written by a justice of the Supreme People's Court. So according to the view of Ms. Zheng, who's a justice of the SPC, when determining whether the court of the state of origin lawfully summoned the defendants, the PRC court should take into account whether the law of the state of origin had been complied with by the court of the state of origin. As long as the court of the state of origin complied its local laws and it could not be found that in summoning the defendant, it is in conflict with the minimum standards for notices to parties or mandatory provisions regarding service under PRC law have been violated. If that is the case, then the PRC court shall recognize and enforce the foreign judgment, even if the service of the foreign court is not via the so-called designated central authority or the Ministry of Justice of mainland China. Okay, that's all for my presentation today. So if anyone has any questions, Patrick and I would like to share our views.
Thank you very much, Charles. Great presentation. I think we had one question from the audience, and I believe Patrick has already responded to it by typing it. And I've shared both your email IDs with the attendees today. So to all the attendees, if you have any questions for either Patrick or for Charles, please feel free to email them directly. The QR codes are on your screen. So if you like, you can take a screenshot of it and scan it later on and get in touch with them directly. So with that, Charles and Patrick, I'd like to thank you both very, very much. Thank you for the presentation and for supporting the In-House Community Dispute Resolution Forum. Thank you very much. And I'll now ask you to please close your webcam, stop sharing your screen, and put your microphones on mute, please. Thank you. Now, it's my pleasure and honor to invite Damien, Laracy, and Felix Cheung from Hill Dickinson, Hong Kong, to start their presentation. There you go. Hi, Damien. I guess Felix will be joining in later.
Yes, thank you. Thank you very much, Rahul. And good afternoon to you and your team and to all of our attendees.
Good afternoon, Damien. Just a quick introduction for both Damien and for Felix. Damien is an experienced litigator and arbitrator who has practiced law for more than 30 years. His practice involves complex commercial disputes and recovery of assets, debts, and damages. He also handles internet and employee fraud, international employee fraud matters, shareholders and joint venture disputes, international trade and sale of good disputes, and urgent interim relief applications. And then we have Felix Cheung, who's a legal associate at Hill Dickinson. He specializes in dispute resolution and handles all aspects of complex commercial and international trade litigation from the courts of first instance up to the court of final appeal. Felix also has extensive experience conducting HAISC, ICC, SIAC, Judicial, LME, LMAA, and ad hoc arbitration. So with that, Damien and Felix, over to you. You can start sharing your screen.
So I head the Hong Kong office of Hill Dickinson, a firm that traces its roots back to 1810. In Hong Kong, as Rahul said, we handle a wide range of disputes and insolvency work, as well as corporate finance and transactional work. You can see from this slide here a few members of our disputes team, and in particular our international trade team. Felix Cheung, who's co-presenting with me this afternoon, is in the middle of the photo at the bottom there. Back to the substance of this afternoon's webinar. We have been hearing from Patrick and Charles about cross-border litigation issues in China and litigation concerning Chinese parties. Some of the issues they discussed concern domestic Chinese law or private international law, or as the American lawyers often call it, conflict of laws. But they also touched on the Hague Convention on Service of Judicial Documents, that is, public international law. Felix and I likewise will also be discussing an aspect of public international law, namely an international convention published by the United Nations Commission on International Trade and Law, otherwise known as UNCITRAL. The convention we will focus on this afternoon is the UNCITRAL Convention on Contracts for the International Sale of Goods of 1980, also known as the Vienna Convention or the CISG regime, CISG being Convention on International Sale of Goods. The UNCITRAL Commission itself was established by the General Assembly of the United Nations in 1973. The convention is due to come into force in Hong Kong on the 1st of December 2022 as a schedule to the Sale of Goods Ordinance, so just over 2 months away. So our presentation is very topical. And I do want to emphasize, though, that the ordinance does, the adoption of the convention, which will be as a schedule to the Sale of Goods Ordinance, does in no way repeal the existing Sale of Goods legislation. The new regime and the schedule, however, nonetheless has the potential to dramatically alter the basis on which Hong Kong parties enter into and enforce contracts for the international sale of goods. Now, another caveat here, please take care when you're talking about the Vienna Convention to distinguish the 1980 Vienna Convention, which we're talking about this afternoon, from two other Vienna Conventions. One of those is the UNCITRAL Vienna Convention on Diplomatic Relations of 1961, and a third Vienna Convention is the UNCITRAL Vienna Convention on Law of Treaties of 1969. The topic we have chosen, being the adoption of Hong Kong of the 1980 Vienna Convention, is a big one. And if we don't do it justice this afternoon in the allotted 30 minutes, please feel free to ask us questions at the end or to contact Felix or myself independently after the presentation. In introducing the topic, I should emphasize that it has relevance not only to transactional lawyers and business people negotiating and preparing sale of goods contracts, but also to those of us who are disputes practitioners. As we will see, for example, it is likely that under the new CISG regime, a Hong Kong judge dealing with a sale of goods dispute may be more reliant on expert evidence than is currently the case. And the reason for that is that custom and usage are expressly relevant to the CISG regime by way of Article 9.2 of the Convention, which I'll come back to a little bit later. So in contrast to the approach of a judge sitting in a court in Hong Kong, a commercial arbitrator who may have the freedom not to treat himself or herself as bound by conventional rules of evidence may be comfortable making a decision concerning the same issues without reference to expert evidence. That is to say, he or she may be comfortable making a decision in an arbitration without reference to expert evidence regarding custom and usage. Whereas a judge in court would be constrained to pay attention to custom and usage if it is raised by way of an application to apply a term. Now, I make that distinction between the potentially divergent approaches of a judge and an arbitrator in order to emphasize the disputes credentials of this topic. And just in case it be suggested that the convention is simply a body of language to be referenced or incorporated by transactional lawyers. It is much more than that, has much more relevance than that. Our slides will be distributed at the end of the presentation. And so we move now right on to slide number 5, which is a fairly busy depiction of the flag states, various jurisdictions that have already adopted the convention. Now, the convention, as I've hinted at, and as is clear from this slide, is a multilateral treaty that seeks to establish a uniform framework for international sale of goods contracts. It's been ratified as at today by 95 countries, representing 2/3 of world trade. So as in that context, it's arguably deserving of the same respect and acknowledgement as the 1958 New York Convention, also published by the United Nations, or the Hague-Visby Rules. But note that 3 of Hong Kong's trading partners are not featured on this slide, that is England, Taiwan, and India. The next slide we will move through fairly quickly. This slide simply records the journey of the convention in Hong Kong to its current status as a schedule to the impending ordinance. We can see that there was a public consultation process that began in March 2020. But note that the schedule to the ordinance does not operate to repeal Hong Kong's existing sale of goods ordinance. That's a point I made earlier, and which we do wish to emphasise. There's very much an opt-in, opt-out regime available here. Moving ahead through slides, the next 4 slides, 7 to 10, I'll skip through these because they simply emphasise the trade connectivity of Hong Kong with the rest of the world. This slide here introduces a basic compare and contrast exercise. And again, before going through some of the elements of the slide, I would ask you to bear in mind that for me as a litigator, the real developments with the creation of this schedule as part of our sale of goods legislation are in the implicit recognition of custom and usage, contracts of sale of goods, and also pursuant to Article 7, a duty of good faith. The courts will imply a duty of good faith into contracts for the sale of goods. So that's a concept that is not commonly known to us common law practitioners in Hong Kong. Now, as you can see from the slide, we've listed 6 features of a common law sale and purchase contract. There's a 7th item at the bottom which relates to breach. And we treat breach separately for immediate purposes. But it will be readily apparent that in relation to the 6 features above breach, in each case, the convention regime requires a court or arbitrator to consider trade practice and usage. And as I hinted at earlier, in addition to that, under Article 7, the court or arbitrator may be required to consider aspects of good faith. So this echoes my earlier remark that certainly in dealing with issues of trade, custom, practice, and usage, going forward, in circumstances where the schedule is relevant to a sale of goods contract, there may be a need for more reliance on expert evidence and dealing with disputes under the convention. But again, I do need to emphasise that the sale of goods ordinance regime will remain extremely relevant. The first column, for example, will remain relevant, and it will only be less relevant in circumstances where there is an opt-out provision in favour of the schedule. So, for example, a Hong Kong exporter can still contract on terms that will apply Hong Kong law, but expressly exclude application of the convention. So in those circumstances, the sale of goods ordinance will continue to apply as it is without reference to the schedule. Alternatively, the same Hong Kong exporter could apply Hong Kong law and expressly apply the convention, but with some terms in the contract inconsistent with the terms of the convention. So the convention in those circumstances would be ousted in those limited respects. Similarly, a Hong Kong exporter could provide in its contract for English, Taiwanese, or Indian substantive sale of goods law. In those circumstances, there would be no application of the convention whatsoever, so no application of the new schedule. Now, in such cases, the relevant domestic substantive sale of goods law of England, Taiwan, or India will continue to apply. However, as from the 1st of December 2022, there is no escaping the fact that if a sale of goods contract governed by Hong Kong law does not derogate from the convention or is silent as to certain terms appearing within the convention terms will be relevant. So it will be relevant to look at custom and usage, and it will be relevant to consider good faith. And this is clear from Article 9.2 of the convention, which provides, and I'll paraphrase here, we don't have it on the slide for you at the moment. It provides in Article 9.2 that the parties are considered, unless otherwise agreed, to have impliedly made applicable to their contract a usage of which the parties knew or ought to have known, and which in international trade is widely known in the particular trade concerned. Now, to me, the important takeaway from that passage is the clear reference to customary usage. The parties are deemed to have included in their contract terms that are consistent with such usage. Now, as we will see, one important impact of that deeming provision is that a party may not need to trouble a court or an arbitrator going forward about implying terms into a contract regarding custom and usage on the basis of commercial efficacy. So in circumstances where the schedule is relevant, those terms don't need to be applied because they're already very clearly stated to be relevant by virtue of Article 9.2. Thank you for listening. I'll now pass you over to Felix for a deeper dive into the workings of the convention.
Thanks, Damien. We have obviously learned from Damien why this convention is very important and how it is important. And the next question you may ask is, what is important in this convention? You may think that the substantive rules under this convention are very important, but we can tell you from the very beginning that this is not the case. The substantive rules are very important, but they are this important, bearing in mind some underlying or overriding principles that is set out in the convention itself as well. So I will now go more deeply into those things. First thing we would be concerned with is obviously the scope and applicability, because if this CISG doesn't apply to any contract, then we don't need to concern about it. This is Convention on International Sale of Goods contract. So we will be concerned what is a sale and what is a contract, what is a goods, and what parties it apply. Unfortunately, there is no definition, but there are some exclusions and there are some performance duty that we can draw implication from. For example, the buyer has to pay the price, the seller has to deliver the goods. Then you can imply from those provisions that whenever there is a contract where the buyer pays the price, seller deliver the goods, that is a sale of goods contract that will be governed by the CISG. There are other exclusions like judicial sale, vessel, aircraft, and there is also one more interesting exclusion, which is electricity. And by that, you can also draw an inference that sometimes utility, such as gas, oil, water, can be included, or CISG would be applicable to those utilities. Now, what parties does it apply to? It applies to seller, it applies to buyers. Does it apply to manufacturer or distributor, for example? Now, if the buyer supply all the raw materials for the seller to just process it, then CISG does not apply. Take this as an example. If you bring a fish to a restaurant in Saigon and ask the chef to cook it, that is not a sale of fish. That is simply to process the fish. That CISG doesn't apply. So that's as simple as that. Whenever you think of the applicability of CISG, you think of a Saigon restaurant and you think of the fish, whether you bring it to it or you buy it from the restaurant. Now, I'm taking the reverse back. It's not as simple as that because CISG doesn't apply to a Saigon restaurant. It applies to parties that have business in different contracting states. The place of incorporation is irrelevant. The place of the signing of the contract is also irrelevant. It is the place of business that matters. Now, what if those parties have one more place of business, like McDonald's and KFC, for example? Now, that it is the place of business that has the closest relationship with the contract and its performance that matters, like a McDonald's US branch buying chicken from KFC Lebanon, then it applies. But if it is the McDonald's US branch, like California buying chicken from the KFC in Seattle, then it doesn't apply because they are both US. Obviously, as Damien has mentioned, parties of autonomy does matter. So there is always autonomy to opt in some of the provisions and opt out some of the provisions. If only one party is located, has the place of business in the contracting states, then we need to resort to the private international law rules and see whether the contracting states law applies or not. That deals with the scope and applicability of CISG. Now it goes to the structure and interpretation. That is also very important because after you know the structure and interpretation, you would rather spend the time to know the industry, know your client, know your business partner, rather than spend the time reading all the law and provisions under CISG. And I hope after this seminar, we understand our client better as a private lawyers, as an in-house counsel in trade finance or in trader, for example. The entire CISG has 101 provisions. That's a lot. But the architecture of it is rather simple. It contains 4 parts. First part, that is the scope and applicability, which we have neatly summarized for you. Second part is formation of contract, which I will not go into it because all common law lawyers will know that and they simply over and acceptance, and CISG doesn't order that much. But the third part is the substantive rules, which govern the buyers, sellers' obligation, and their remedies. I will later give you a poll and see whether you are interested for us to go briefly into it or not. If not, then we will go directly into the interpretation, which is the more important part. The last part of this convention is simply public international law. Damien has mentioned some of them. Now we are going into the convention itself, which is private law elements, and we as private lawyer don't need to concern much. Now this is the hierarchy of interpretation, and I would say this is the most important slide on my part. Well, who can I trouble you to start the poll and see whether the audience after this slide would be interested for us to go briefly into the more substantive obligations and remedies of the convention. Now we can see from this hierarchy that what matters most at the upper level is the overriding principle that this is an international convention. So we observe the international character, we stress the uniformity of application of it, and we observe good faith. The entire CISG will work.
Right, Felix, just 1 second. The attendees won't be able to see your slide because they've got the poll in front of them right now. So just give me 10, 15 seconds more to collate all the poll, and then I'll share the results on the screen.
No problem. Thank you, Rahul.
There you go, Felix. The results are in front of you.
So what's the result? I can see.
Right. So should the presenters go briefly into the parties' duties and remedies, or should we go directly to happy hours on Thursday? Surprisingly, only 11% said, let's go party at Hill Dickinson office. Majority of them said, let's go briefly into the substantive rules. That's your result.
Great. So I cannot go off for beer very soon. Now, let's talk about this pyramid first. And to observe the international character, the uniformity of application, and good faith, CISG works to preserve the contract to the maximal extent. Now, after we observe these underlying objectives, principles, then the party's autonomy and party's intention must matter before any substantive rules go into play. The party's intention can be ascertained subjectively or objectively, and the tribunal or a court can go into the pre-contractual negotiation to ascertain the intention of the party. And that is rather uncommon under common law because we will only read the express provision. So if the express provision doesn't provide that, we will not apply an intention into it unless there is very cogent evidence. But that cogent evidence would usually not be sourced from the pre-contractual negotiation. Under CISG, that is different. Party's intention must matter before anything else. Now, if the party's intention is still unclear with all the circumstantial evidence, then the trade usage and the customer practice between the parties would go into place. As Damien has stressed a lot, trade usage matters before the rigid substantive rules of CISG, because CISG does respect commerciality. This is a very commercial convention, and as it is automatically implied. So I say we should understand our business partner more, understand the industry more, understand our client more before we advise on the substantive rules, which I will go briefly after that. Now, it is only after all these 3 levels that we cannot ascertain what the contract is about. that we go to the substantive rules of this CISG in order to ascertain really the obligations of the parties, the duties, whether there is any breach, and what the remedies will be if there is any breach. And we are going into the substantive rules. The seller's duties and the buyer's remedies go in pair, and vice versa. When the seller breaches duty, obviously buyer has a remedy. I will assume that everybody would know about SOGO, Sale of Goods Ordinance. So I will just briefly mention what is identical or similar to SOGOs and what is different. Seller's duty is quite similar. They need to deliver conforming goods. If there is non-conformity, obviously there is a breach. If there is non-delivery, obviously there is a breach. Now think about this. If a buyer purchase or order 50 tons of apple, and then the seller deliver 50 tons of orange to the buyer, would that be a delivery or non-delivery? I will give you 10 seconds to think. 10 seconds have passed, and I will go back to this if you are interested in the Q&A section. So you take the time to think about it, whether it is delivery or non-delivery. Orders, duties on delivery, and whether it is conformity, etc., are very similar to SOGO. So I'll just skip it. Standard of goods, also similar to SOGO. You have to fulfill the purpose, adequate packaging, etc. Now, assuming there is non-conformity, then that's the part where the parties have to compete with time. And we, as private lawyers, have to advise the client very urgently what they need to do. For seller, if they deliver early than the delivery date, then they have an automatic right to cure the defect. They can re-deliver, they can repair, etc. The right is automatic, and the buyer can't say no. If they only deliver at the delivery date and there is defects, there is still an automatic right for the seller to cure, to repair the cargo which is defective, provided that it does it very promptly and does not cause any inconvenience to the buyer. So the buyer still can't say no. But what the seller has to do is to compete with the time. They have to do it very promptly. Now suppose buyer doesn't do anything with the non-conforming goods. The buyer then still have to compete with the time. They have to examine the goods very promptly. And if they don't do it, then they lose the right. After examining it, if it discover any defects at all, still, buyer has to issue a notice of non-conformity very promptly. And in any event, within 2 years' time, if it does not do it, then it loses the rights to complain about non-conformity before a tribunal. The last question, what if the seller simply know about the defect and the buyer doesn't examine it, or after examination doesn't discover it? What would be the case? In that scenario, the seller would not be entitled to rely on the absence of a notice of non-conformity to excuse itself. But of course, then buyer has the burden of proving that seller has the knowledge of the defects, and that will be very difficult. Now we assume that seller has breached many of his duties. What's the buyer's remedy? Some of them are similar to SOGO and common law, and some of them are different. Performance is different. Avoidance is probably similar. Price reduction is a new concept. Damages is similar. Exemption is about force majeure, which is quite similar to a force majeure clause in a contract or the concept of frustration under common law. Now, what is performance? Performance is to say that the buyer can compel performance if there is a breach. By saying compelling performance, it adds nothing to just making a request, right? But the rules actually add something, because the buyer can request the delivery of substitute goods. They can request the repair by the seller if it is covered there is a breach. They can make this request because they are provided under CISG, and this falls to buyer's request. But to say compelling a performance out of a seller doesn't mean that buyer is entitled to specific performance automatically. The answer is a no, because the CISG expressly preserved the court's discretion as to whether it will order specific performance. So you may ask, what does it add to common law, or what does it add to SOGO? Practically, it does not add anything. Legally, some confidence is added to buyer to make that request. Now, the contract can be avoided, whether it is a breach by buyer or by breach by seller, if there is fundamental breach. Fundamental breach is a doctrine that is already abolished in common law, but I believe all common lawyers know what fundamental breach is. So I'm going to skip this. Basically, if you breach a condition, that is probably a fundamental breach. Now, the last risk concept is quite new to common lawyer. The term is new. It is a German word. It means that the buyer can allow an additional period of time for the seller to perform its duty. And if the buyer allows that performance time, then the buyer cannot complain and cannot avoid the contract within that period of time. It's only if the seller refuses to perform within that additional time or simply doesn't perform at all, then it returns, it becomes circular, it returns to the original position that the buyer may avoid the contract if it is a fundamental breach or may claim damages if it is not a fundamental breach. Price reduction. This is a very interesting concept. If the goods is not confirming and it is actually a cheaper goods upon delivery of the goods, then the buyer has an automatic right to reduce the price. It can be by way of paying a reduced price or by way of asking back the price already paid to the seller. Another question for brainstorming, if the goods is non-conforming and there is no value in the goods at all, can the price be reduced to zero and buyer keep the goods? Again, 10 seconds for you to think about it. And I will not answer it now. If you're interested, you can ask it in Q&A and I will answer that. If you are not interested, then you can further investigate it. Now, buyer's duty, even easier. They simply have to take delivery and they have to pay the price. If they don't do that, then quite obviously those are fundamental breach and seller can avoid the contract. But whether it would like to do it or whether it would like to claim other remedies is something for us lawyers to advise, for in-house counsel to advise their business unit, for us private lawyers to advise our client. This is another brainstorming question. Basically, one article in this CISG says, if the contract is certain enough, then it will be formed. And if the price is fixed, it will be certain enough. Another article in this CISG says, if the price is not fixed, then it can be later determined. Then the question comes, whether fixing price is a prerequisite to the formation of a contract. This scenario has not been tested before by any precedents, but the predominant academic view is that it can be formed, provided that the trade usage, the market practice can help to determine the price later on after the formation of the contract. Then that goes back to what Damien says. Evidence, expert evidence may be required rather than us lawyers interpreting the strict legal rules because we simply can't get the answer from these two rules. Now, what's the seller's remedies? It basically regards what the buyer's remedies are. So they can claim damages, they can avoid the contract, etc. So I need not go deeply into it. I will now pass it back to Damien to summarize or to wrap up everything we have talked in a neat way so that you know what's the key takeaways.
Thank you, Felix. We're coming to the end of our time here, so I thought we'd just return to a slide that I took you to earlier. And the point I'll make here is that with the evolution of our sale of goods ordinance that will take place on the 1st of December, we are now going to have in Hong Kong a little piece of civil law, basically. You've heard reference this afternoon from Felix talking about German concepts of Nachrecht. We've heard about concepts of good faith. We've looked at interpretation of contracts by reference to the intention of the parties, which is not normally the way that we look at contract interpretation issues in Hong Kong. Some quite foreign civil law concepts creeping into our sale of goods legislation. But as I say, and we see the references up there to Article 9, which does enshrine the concept and the relevance of custom and usage. Have a look also at Articles 7 and 8. And at that point, I think it's time for some Q&A. Thank you very much all for listening.
Thank you very much to Damien and Felix. Unfortunately, we have run out of time. If you have any questions, I've actually, with the attendees, I've shared the email IDs for both Damien and Felix. If you need a copy of their slides or if you have any questions, please do reach out to them, and they'll be more than happy to get back to you with the answers and the slides. Right. So Damien and Felix, thank you very much for taking out the time and for supporting this particular webinar. Thank you again.
Thank you.
Thank you.
Wonderful. I'll ask you to now stop sharing your screen and close your webcam and mute your microphone. Thank you very much to all the attendees for joining us today for this particular webinar. One Hong Kong CPD point has been applied for this particular session. And once this is approved by the Hong Kong Law Society, we'll be sending you all an email to inform you that the CPD points have been given. Again, thank you very much to the two law firms supporting this particular webinar, Llinks Law Offices and Hill Dickinson, Hong Kong. I mentioned at the beginning that we have a couple of events coming up. These are both in-person events. Our Kuala Lumpur In-House Community Congress 2022 will be taking place in person on the 12th of October at the Intercontinental Hotel in Kuala Lumpur. If you are interested, whether you want to travel to Kuala Lumpur now that we can, or perhaps you have colleagues or friends, in-house counsel friends in Kuala Lumpur, please reach out to us and we'll share the information with you. Alternatively, you can also visit our website, www.inhousecommunity.com. Go to events, and all the information about the Kuala Lumpur event is there present. The second event, more concerning everyone over here, is the Hong Kong In-House Congress 2022 in-person event, which will be taking place at the JW Marriott on the 15th of November. That's a Tuesday this year. It's going to be a live in-person event. We have some restrictions around the number of people we can bring in. So the invitations will be going out very, very soon to in-house counsel in Hong Kong. If you're interested in it, please let us know. There is something within the post-event survey which you can enter and you can pass on your request. So thank you very much again, and please wait for this query for the survey to pop up on your screen. If you don't see the survey on your screen right after we close this webinar, it will be sent to you by email tomorrow. And thank you very much. My name is Rahul Prakash, and we'll see you hopefully live in person. Bye-bye.